Welcome to the Cyber Risk Management Podcast. Our mission is to help you thrive as a cyber risk manager. On today's episode, your virtual Chief Information Security Officer is Kip Boyle, and your virtual Cybersecurity Counsel is Jake Bernstein. Visit them at cyberriskopportunities.com and focallaw.com.
So, Jake, what are we going to talk about today?
Today, Kip, we're going to talk about the FTC's data security regulation and why we always seem to get settlements rather than litigated court outcomes.
What a great lawyerly topic. I guess I've been monopolizing the script too much lately. How did this come up?
Well, actually, Kip, you picked it.
Okay. All right. Really?
Yes. In fact, the issue was raised by a fellow CISP named Jacob on LinkedIn. Here's a shout out to Jacob Horn.
Hey, Jacob, thanks.
And you suggested it would make a good podcast topic. So here we are.
Yeah, no, that's true. I just didn't realize it was going to come up in the order in which it did. But that's great. So I guess nobody in the audience can blame Jake for creating a law-focused episode. I am your partner in crime. All right. Well, let's set things up. So how are we going to do this?
Well, I think I'm going to ask you, actually, what made Jacob's LinkedIn post so interesting to you?
Well, one of the things I like about it is Jacob is a practitioner, and I always enjoy talking to people who are out in the field trying to manage cyber risk. And so anytime somebody who's actually in the field, says, "Hey, this is important to me," I automatically count it as being interesting. And then when I read his LinkedIn article, which is still up there, and you can read it too, I thought, wow, what this is great, because settlements just are not as emotionally satisfying as wrap the gavel, you're guilty, and I'm going to punish you stuff seems to be. And maybe that's because I watch too much TV. I don't know.
Oh man, there are so many legal problems with that statement. So first of
everybody, remember, I'm not a lawyer.
Yes, no, it's true. So anyway, as you may expect, I have quite a few thoughts on this whole topic. And yes, I am a lawyer, but our listeners may not know that I worked very closely with the FTC for almost a decade in my role as a consumer protection attorney with the Washington State Attorney General's office. And actually, I practiced the same type of, quote, regulation, end quote, that the FTC does using the Washington Consumer Protection Act, which, believe it or not, and you may laugh, is often referred to as a baby FTC Act.
A baby FTC. So, oh my gosh, I can go so many places with this, but I won't. But when you say Washington Consumer Protection Act, is that Washington State or Washington, D.C.?
Washington State. And every state has
okay.
some kind of...
So we have the baby FTC Act here in our state. Okay.
Yeah. And there's actually quite a few baby FTC Acts around the country.
Oh my God, you're just opening the door. You're just baiting me to say things I'm not going to say.
Okay, so let me explain. The operative language of the FTC Act is actually quite short. And just to paraphrase it, unfair or deceptive acts or practices in trade or commerce are hereby declared unlawful. And what makes a baby FTC Act, like the Washington Consumer Protection Act, is that it uses the same language. And the reason that we say baby FTC Act is that there are actually other types of consumer protection acts out there among the states. I want to say, for some reason, Illinois comes to mind, that are not baby FTC Acts. They're just different. Sometimes they have lists of unfair, deceptive acts or practices. Sometimes they have just a largely different structure. But yeah, that's why we call it baby FTC Act.
Okay. So very interesting. But is it relevant or important to our audience?
It is. It's very important and relevant. And there is this misunderstanding out there. And again, shout out to Jacob Horn for valiantly trying to correct it, about the FTC and its powers. What's the misunderstanding?
Okay. The misunderstanding? So the FTC has the power to regulate
the FTC is not a regulator in the same sense that, say, the FDA or the SEC are regulators. Those agencies set detailed rules, which we call regulations, hence the terms.
Yep.
And while courts can and do get involved, the agencies themselves have a fair degree of power to enforce their own rules and regulations. Um, Now, the FTC has promulgated a few regulations, but they are really specific and they don't yet relate to security. In fact, some of some of the more famous ones are there's a canned spam regulation that's very specific, and then probably the most important one is the so-called the telemarketing sales rule. And
So okay, so wait a minute. So Washington State has a baby FTC Act, but now based on what you said, now I'm thinking of the FTC as a baby regulator with respect to the FDA and the SEC. How
uh,
interesting.
Yeah, I wouldn't call it a baby regulator. I mean, on the one hand, it has a vastly larger purview than either the FDA or SEC. And what I mean by that
Mm.
is that the breadth of industry that it regulates is unparalleled. Actually, no
Ah,
other regulator has such a broad, kind of broad
landscape, huh?
broad authority, is what I would say.
Broad authority. Okay.
Yeah, and but I think when people think about regulations, they do tend to think about very detailed sets of rules that have to be followed.
No,
And
that's true. I mean, if you're a publicly traded company, I mean, there's books full of them.
yeah, exactly. Well, there are they exist whether you're a publicly traded company or not in some cases. But so to differentiate, the FTC has called itself, and I agree with this, a civil law enforcement agency, and that's pretty much the same thing as states' attorneys general. Uh, and what it means is that they primarily do their job via investigations and lawsuits. And I
Huh.
do not want to take the our audience down the Administrative Procedures Act and the differences between agency action and court action. So, but let me just leave it at it's really complicated, and there's a lot of nuance there.
Mm-hmm.
But with the FTC, largely you largely the FTC does its job by suing companies.
Mm.
That's what it does, and that is quite different in a lot of ways than kind of a typical quote regulator. What you think about. Um, so yeah,
Okay. Now, because I'm not a lawyer, you and I have had conversations in the past about law, so that I could, kind of, sort of keep up with you. And so, one of the things that I learned is that civil lawsuits, in that arena, litigation to the bitter end is a rare thing. Am I remembering that right?
no, that's exactly right. I mean, it's extremely rare, actually. I think depending on the state or federal district court you're in, uh, easily more than 90% of all civil lawsuits will settle.
Hmm. Okay. And so what Jacob said in his post is the reason why 90% or more of these civil lawsuits are settling is because of the expense and because of the uncertainty. I mean, both sides really go into it. They know what they want as far as an outcome is concerned, but there's still a lot of uncertainty. Um, but I mean, I mean, what does the FTC have to lose? I mean, why wouldn't they just fight it to the bitter end? I mean, that's what they do, right? That's their job.
So, I mean, that is a very fair question and a good point. And when I was at the Attorney General's office doing civil law enforcement, this question wasn't just hypothetical. I lived it, and particularly when defendants would sometimes forget that it was my job to bring cases, and they would try to scare me away from court. Um, that doesn't work directly. But what
Mm,
does work in every case is bringing a reasonable defense before the regulator and convincing the regulator that, hey, look, a court may not agree with you. And, uh, you know, that is something that a regulator does not want to deal with because losing ends up being a waste of time, resources, money,
And it goes on their permanent record too, doesn't it? I mean, like
Well,
they,
I mean,
like you lost this, and doesn't that kind of undermine their authority in the future on that issue?
so the answer, of course, is it depends. But broadly speaking, yes, it does.
So they have a lot to lose, or they could have a lot to
They
lose. So,
do. They do have a lot to lose. Yes.
okay, so that's kind of why. Again, to answer the question, that's why the FTC wouldn't necessarily find it risk-free to litigate to the bitter end.
It is definitely not risk-free for any regulator to litigate to the bitter end.
Okay, got it. Okay, but I have to point out that you just used the R word.
Reasonable. Yes, I did, didn't I? And there's no magic to the concept of reasonableness in the broad sense. And the idea there is that if what you did or didn't do was reasonable, then a judge is unlikely to say you did something wrong enough to impose liability.
Yeah, and in a previous podcast, we talked about how a business decision maker actually has a lot going for them because of the what did you call it now? The business judgment rule. I mean, there's a
rule. That's right. Good job, Kip.
Hooray!
You've kind of gone through a bit of law school, haven't you?
That's what happens when I hang out with people like you.
Yeah. Well, but
that tells you that a business actually stands on some pretty good ground already.
It does, and I think one thing I wanted to point out real quick is the very beginning of this episode. You had said people kind of they have this emotional reaction and they kind of want to see the gavel banged against the big desk and a guilty imposed. And I want to point out that in law, as in everything, the language and choice of words can make a big difference. And it's important to understand that in civil court, we say liable, we don't say guilty or not guilty.
And Hollywood is so much more fun.
Yeah, well, it is. I mean, so guilty and not guilty is for criminal court, right? You're either you're guilty or not guilty of a crime.
Mm-hmm.
And if you think about it, that's a very binary. That's a binary status, right?
Yeah. Because then you're in prison or you're not in prison. I mean, it's a big life changer.
Exactly. Now contrast that to liability. Liability. Okay, so 1 week I could say you're either liable or you're not, and that does happen. But more often than not, you are liable. The question is how much, and that is a very analog question. You could be liable for $10, or you could be liable for $10 million. So it's not enough to say liable or not. You have to figure out how. And you could argue that guilty or not guilty and the length of your sentence gets taken into account. That's true. But, civil liability is, there's always this question of how much. And it comes back to classic, ancient tort law. And I don't mean tort like the dessert. I mean,
you're making me hungry, man.
I know. Tort law, as in, the negligence standard. And,
okay, so that kind of gets us back on topic, right? Because really a lot of cybersecurity is about, were the decision makers negligent or were they reasonable?
Yeah, and what's interesting is that, negligence is really about, it's really a two-part question. Did a duty exist, and did the defendant violate that duty? And it gets, obviously I'm oversimplifying, but what you might have noticed is you don't see a lot of cybersecurity lawsuits that get a lot of press about the negligence standard. And I think that's because, one, it's not clear what kind of duties there are for cybersecurity. And when I say duty, I mean a common law duty, meaning that something that a judge has said is a duty that can be violated. But the duty of care, it is combined, and these concepts will start to collapse.
Yeah.
And so the reasonableness standard is basically where we are right now.
Well, and that kind of makes this time and the work that we do so interesting, right? Because it's not settled. Now, we can't just go to a book and look it up. I mean, it's being formed.
Yeah, exactly. I mean, honestly, if it was, shout out to you and your book, Fire Doesn't Innovate. Fire law would be pretty darn boring. I would not be in it very long. The question would be, okay, there was a fire. Yep. Did you have sprinklers? Nope. Okay, you're liable. and
Let me run the checklist.
and that's boring, right? That's super easy and boring, and it's so boring and so easy that it's all been kind of that used to take place in court. Now it's done by insurance adjusters, right?
Yeah, and apologies to any attorneys out there that are practicing in fire law, but that's just kind of what it looks like from where we are.
Yeah, exactly. So anyway, where am I going with all of this is the bottom line here is that the FTC can't just declare something to be unlawful. It has to prove in court that a defendant committed one of those unfair or deceptive acts or practices that I mentioned. And right now in cybersecurity, that means failing to employ reasonable safeguards to protect the confidentiality, integrity, or availability of data, given the type, amount, and sensitivity of that data in relation to the size, sophistication, and capability of the defendant.
Don't tell me you memorized that. Don't tell me you memorized that.
I wrote it down, but it is the FTC's cybersecurity standard. That's what they have said. That's kind of how it looks.
Okay. All right. So the FTC can make allegations about a company's cybersecurity practices, but it can't just come out and say, you did that wrong.
Right. Or more properly, that's what it says, but it doesn't. Mm-hmm. But so what until a court agrees?
Ah.
Right.
Okay.
So yeah.
Or until a settlement.
Or till, and that's what I was going to say. So, the FTC has to then be able to prove the allegations in court. And just a quick aside, I think there are definitely going to be listeners who wonder if courts just don't, doesn't the court just do what the FTC says because they're both government? And, I can assure you on personal experience that this is not the case.
What? You mean the United States isn't just some kind of, monolithic, you rub my back, I rub yours thing?
Well, I mean, there's a reason that we have and I'm trying to think of another example. I don't think there are many of other countries where there is a constitutional 3 independent branches of government. And this is why, right?
Civics. I'm in civics class.
You are in civics class. It's super important. If the courts were just part of the executive branch, then yeah, who really would expect them to be fair and impartial? They would be on the same side as the FTC. But having experienced this with the independent judiciary, you are as likely to find judges who lean against the government as well as towards it.
Okay. So we're back in civics class, and we've just kind of, gone over the territory here about, leading up to the question, which is why does the FTC settle all its cases, and what's at stake for them?
So that is a very interesting question, and I can speak to it both as a defense attorney now and as a former civil law enforcer. And there's an old saying in law that bad facts make bad law, and no agency wants to be responsible for creating bad law. Now, it stands to reason that the easiest way to avoid that would be to avoid bad facts. And this is why you see the FTC bring, quote, easy cases, hearkening back to Jacob's, his LinkedIn article.
His article, yeah.
Yeah. And so, in theory, no rational defendant should litigate a, quote, easy case, easy from the FTC's perspective. So they settle to save money and to be cooperative.
Okay. All right. So that makes sense. But I feel like I would like to understand just a little bit more about the phrase you said, bad facts. That sounds, okay. So that sounds confusing because to me, a fact is, that's undisputed. The sun is yellow in the sky or whatever, right? But then a bad fact, it's like, okay, well, now you're starting to sort of imply, some sort of judgment or interpretation of a fact. But what do you really mean when you say a bad fact?
So bad facts from the perspective of the plaintiff, which means the person who's trying to bring the case.
So facts that are not in their favor.
Facts that are not in their favor. And sometimes there are, what it's getting at is that under our system of law, which there's a lot of it is statutory law, which is written down, but a lot of it is, quote, common law, which is judge-made law, which is law that you kind of glean from how cases happen.
Is that also called case law?
It's also called case law, yes. Well,
I knew watching all those lawyer shows were going to pay off.
The case law defines the common law, is what you mean.
Okay.
So in any event, though, you know, if a case has hyper-specific facts, then its utility in the future may be very limited, and that can be that's usually not a problem, right? But when a case has broad facts, then that is more challenging because its applicability over time is going to be much greater. And if those facts don't fit with kind of the plaintiff's goals with the litigation, then you can get bad facts. And
okay,
a good example of that, let's say, is when you have a defendant who's either not completely rational or who just really believes in their position. And look at what happened when the FTC had litigated against LabMD.
Yep, we've talked about that before.
We have. One could call that a bit of a debacle, really. LabMD fought and fought and fought, and they won some victories. And those victories do potentially, throw the FTC's ability to regulate cybersecurity issues into question. And let's, contrast that with the very first case that the FTC took up on appeal, which was in cybersecurity, which was the Wyndham case. And those facts were so bad, so egregious. They were great facts for the FTC, and there was no risk really that they would lose. But
it certainly didn't seem like that from Wyndham's point of view, because they just went down swinging.
Well, it was pathetic, really. But the problem with that too is that from our perspective, and we have talked about this before, what did we learn from Wyndham? Like, what can you say is the takeaway from Wyndham? And the answer is, well, do something. Don't be as bad as them. And so it's all very complicated is what I'm getting at. And with the FTC and settlement, you've got a lot of different factors going on here. The FTC doesn't want to bring cases that are that it might lose, because then it could actually have its powers contracted going forward. And there is also simply an issue of resources, public resources. At the end of the day, these regulators, these civil law enforcement agencies, are government entities that are supposed to be serving the public interest.
Yeah.
And do we really want a particular attorney inside one of these agencies to wage a crusade on a pet issue, and use up 5 years of resources when he could have settled 15 cases in the same time period and gotten something for the consumers during that time period? So
yeah, it's interesting. They kind of have the same problem that our audience has, where cyber risk managers have more risk coming at them that they could possibly deal with, and so they have to make tough choices about well, what's top, what's a top risk, and then how can I put my limited resources to the best use? Yeah,
exactly, and that is, that is the case. I would say, for all regulators, is that there's probably more violations than they will ever be able to fully deal with. And so they have to decide what cases can we bring that are going to have the greatest impact and benefit the public good. Every once in a while you need to bring a hard case. And you know what? Those cases stand out in history. Standard Oil, was an immensely important case in the history of antitrust law. There's some tobacco cases related to consumer protection and the Federal Trade Commission in the 70s that were absolutely critical for the development of this law. But those are rare, and those become historical events, at least to lawyers. So, I think to kind of wrap this one up, Jacob's points are very, very good in his LinkedIn article. There's nothing, and I really want to dispel this notion that somehow a settlement means that the government gave up.
Oh yeah, that's a great point, because settlement does sort of carry that connotation.
Yeah, it doesn't, and particularly with respect to the Facebook settlement that people there was a lot of complaining about the Facebook settlement. You know, it wasn't enough. It wasn't this. They didn't do enough. Why did they stop?
Yeah.
And the fact is that, you know, first of all, the Federal Trade Commission brought that fine using an existing consent decree. So right away, that makes it a little bit different than a new lawsuit. It was not really a new lawsuit. And second, you know, $5 billion is still the largest consumer protection fine in the history of consumer protection by a significant margin, orders of magnitude, really. And for the FTC to just get that without spending, you know, 5 to 10 years litigating is an immense victory of, you know, frankly, legendary proportions among regulators. So the idea that settlement means the government somehow gave up or didn't do enough, that's just not accurate. You know, settlement is how 90% plus of all civil cases get resolved. All it means, really, is that one side or the other decided that, hey, you know what? It's just not worth the risk going forward.
Right.
And then on top of that, in settlement, you know, there are this, and this is almost counterintuitive, but settlement can sometimes be better for the regulator than actually going through to a lawsuit. And the reason for that is that there's a limit on the type of relief, on the type of consequences a court can impose, right?
Mm-hmm.
There's only so many different types of things that can be done. Whereas a settlement is an agreement, and the two parties can agree to almost anything.
Right.
And so there's a lot more flexibility, and all of it comes down to this negotiation of weighing, you know, potential court consequences and costs versus whatever the agency wants.
Right.
So,
yeah.
You know,
well, and, you know, it's also interesting, too. I think something that sort of adds fuel to the fire here is, you know, ordinary citizens are just livid at the data breaches and the fact that they can't seem to get compensated, you know, adequately for the harm that they feel that they've suffered. And so I think when they hear, you know, settlement, because of the connotation of a settlement, as in throwing in the towel, giving up, I think that just makes things worse for people's ears.
Yeah, I mean, I can understand that. Now, of course, you know, on the other side, class actions also always settle. And in fact, I got a check today for over $100 in a class action. I've started this little hobby of just, you know, filling out the form for every class action notice I get, and people should do that because that's what those things are there for, and that is, it becomes relevant.
Okay, now you have some lunch money, and I'm going to be looking for an opportunity to help you spend it.
Yes.
Okay, well, I hope for our listeners that we've done a good job of answering the question, why does the FTC, with respect to cybersecurity, always seem to settle, and why we don't get litigated court outcomes? I feel like I know the answer now. And so that wraps up this episode of the Cyber Risk Management Podcast. Today we talked about the FTC, their status as a civil law enforcement agency, and why we see so many settlements instead of court opinions in the cybersecurity arena. We'll see you next time.
Thanks for joining us today on the Cyber Risk Management Podcast. Remember that cyber risk management is a team sport, so include your senior decision makers, legal department, HR, and IT for full effectiveness. So, if you want to manage cyber as the dynamic business risk it has become, we can help. Find out more by visiting us at cyberriskopportunities.com and focallaw.com. Thanks for tuning in. See you next time.